Hi, I'm Dr. Shamik Kotecha from the Kotecha GPS Club, and today I'm joined by Stuart Rudner from Rudner Law, an employment lawyer in the Toronto area. Thank you, Stuart, for joining us. I appreciate it.
Yeah,
For a
thank you for
follow-up
having me back
conversation.
again.
So, in our system of interviews, this is a disclosure for me and Stuart. If you require this is for information only. If you require legal advice, please contact your lawyer. We are just discussing in hypothetical terms. Okay, so Stuart. As we've talked about, one of the things that in terms of employees, the government of Ontario passed legislation that made our layoffs or furloughs to something called infectious disease emergency leave, which job protected their job, but also protected dentists or employers from constructive dismissals if people were laid off for longer than the appropriate time or as allowed by either the law or their contracts. That is going to end. It ended actually July 24th, and thus the legislation deemed that 6 weeks after that date, that leave is no longer applicable. So if you have employees that aren't back to work, you now have different concerns going forward. So that's supposed to end September 4th. So in terms of, I'm going to do a lot of this in a dental perspective. In terms of, if you have employees that you haven't called back by September 4th, do you transfer them onto EI, or are they considered terminated as of that date?
Yeah, so a lot of us are struggling with this. The last time we spoke, there was no infectious disease emergency leave. That came into play on May 29th, late on a Friday, and we all spent the weekend trying to figure out what it all meant. And the reason for that regulation was because under the Employment Standards Act, you have time limits on temporary layoffs. In Ontario, it's 13 weeks, and we were very quickly approaching that 13-week mark, and people were panicking. In some provinces, what they did, which in my view is a lot simpler, was they just extended the time limits. Ontario approached it differently. They retroactively changed all of these layoffs into leaves of absence, the idle, as we've been calling it. But as you said, that lasts up to 6 weeks after the state of emergency exists, which is now September 4th, as we all know. So this was generally a benefit for employers because it extended the amount of time that people could be off work while people got ready to go back to business. But one benefit for the employees, as you said, is it's now a leave of absence. And at the end of a leave of absence, you as an employer must return the employee to their job. It's just like a pregnancy or parental leave. One thing I do want to mention really quickly, you mentioned the constructive dismissal. This will protect you from a constructive dismissal claim under the Act. It doesn't protect you from a constructive dismissal claim at common law. And this can get very complicated, but the bottom line is there still is that potential claim out there. But to your point, so now technically on September 4th, everybody that's on this leave is supposed to be brought back and returned to their position. What if you can't? So the simple answer is you could put them back on a layoff and put them back on EI. The same risk applies that existed back in March and April when we started talking about this, which is if you don't have the right to lay someone off, they could claim constructive dismissal. Most people are not doing that if they think that there will be a job for them in the future. They're going to take a short-term loss to maintain the job security. So you could put them back, and the time limit for layoffs will start again on September 4th or 5th, depending on how the dates play out. If somebody was on a layoff before March 15th, which meant you were being very proactive, then the time before March 15th would already count. So you'd be starting over from however many weeks have already passed. But for most people, most of the clients we work with, the layoff started after March 15th. So you're starting from zero on September 4th or 5th.
Kind of a follow-up to that, that's that scenario. You're bringing them back at a later point in time. What happens if you've decided that you just are, for whatever reason, severing your relationship with that employee at that time? Are you opening yourself up to more legal issues, or if your contract allows you, can you pay them out under the Employment Standards Act?
So here's the risk, is because it's now a statutory leave, you have this obligation to bring them back. Again, it's the same as pregnancy or parental leave. So if you have somebody who's off on parental leave and you just decide you don't want them back for whatever reason, unfortunately, you have that obligation to bring them back. Even you can pay them severance, but that doesn't relieve you of the obligation. So if they wanted to, they can bring a claim to the Ministry of Labor and say that you breached your obligations under the Act. That's the biggest downside to the way that the government of Ontario did this, but you don't really have the choice. In many cases, we work with our clients to be very pragmatic, and they'll go to the employee and just say, look, here's the situation. We don't have capacity. We can't bring you back. And if you can show that, it's important to remember your obligation to bring them back ends if their position no longer exists. So if they're employed in a role and you're just not going to need that role anymore, then you don't have to bring them back. You'll still have to give them severance, but you're okay.
Hypothetically, and we're going to do a flip side a little bit, change it around. What if you have an employee that doesn't want to come back?
Yeah, we're getting this question a lot. And it's actually somewhat shocking to me that there seems to be this misguided notion out there that going back to work is somehow voluntary. And a lot of things have changed over the last 5 months. But the fact that you have to go to work hasn't changed. And so I've been saying this a lot lately, in normal times, pre-COVID times, if somebody goes to work on Monday and Tuesday, they can't just decide on Wednesday that they're taking the rest of the week off. The same principle applies if you've been on a layoff or on leave and you've now been recalled. You can't just decide you're not ready to come back yet. And if you refuse to come back without a lawful reason, you're effectively abandoning your job or resigning from your job. And when I say lawful reasons, there's really three exceptions to this rule. One is if you are entitled to a leave of absence, like the infectious disease emergency leave we talked about, or emergency leaves generally. If you cannot work because of COVID-19, you're generally going to be entitled to a leave. Second exception is accommodation under human rights. So if you have, for example, some sort of medical condition that causes you to be more susceptible, you have medical documentation saying you can't go back to the workplace, that's the second exception. Or you have childcare obligations, and this is not preference, but obligations, then you may not have to go back to the workplace. Or there's a right to refuse unsafe work, and I think we're going to talk about that a bit later. But if you can show that your workplace is unsafe, then you don't have to go back until it is safe. Those are the three exceptions. Other than that, people don't have this choice of saying, I'm not ready to come back yet. And we've helped a lot of employers through this somewhat difficult process of basically taking a hard line and saying, we need you back. And if you don't come back, then your employment is over.
Yeah. Well, as you alluded to, the next question is going to be highly contentious, especially in Ontario, is what happens, we're going to talk hypotheticals, what happens if, in this case, it's a hygienist, doesn't want to come back to work to their position because you won't comply to what their college is requiring, but your college is not. And it's been a tough battle, and I feel for a lot of hygienists because they're stuck between a rock and a hard place, as are the dentists, but everybody is here. So how do you deal with that? And I don't know if there is an answer.
I feel for the dentist in particular. You're really stuck in a lot of, you got two different colleges. They're both legitimate organizations. They both have people's best interests at heart, but they have two completely different sets of rules. And you've got hygienists who are saying, I want to make sure that we're following my college's rules, and dentists who are saying, we can't afford to, et cetera. So what do you do? So here's the important thing to remember. Colleges do not create law. The guidelines they release are not legal requirements. There's lots of guidelines out there. Many of them have been put out by government agencies, health agencies. As an employer, your obligation is to take all reasonable steps to provide a safe workplace. So you're going to have to ensure that you can justify whatever you're doing or not doing. You're going to have to show that you made a legitimate effort to ensure the workplace was safe. If you chose to follow certain guidelines, such as your college or any other government organization, make it very clear that you did follow them and why. And ultimately, if there is a dispute, what this comes down to is the workplace unsafe? And any employee can call the Ministry of Labor and say, I think my workplace is unsafe. And the Ministry of Labor will assign an inspector, and they have bolstered their numbers. They have a lot more inspectors now than they did back in February. And they will investigate, maybe on premises, maybe by phone, but they will investigate, and they will assess if there is a legitimate, objective safety risk. So it's not enough to say, my college says that the dentist has to do this, and they're not doing it. The inspector is actually going to either come in physically or at least understand the situation to assess, is there a real risk to your health or your safety? If there is, then they will uphold your refusal to work. But I will tell you that there have been, there's a lot of stats, and the stats I've seen are a little bit out of date now, but there were hundreds and hundreds of complaints of unsafe workplaces and a handful that were upheld. So far, the inspectors are really siding on the side of the employers to date.
Yeah. Well, so along that same lines, is there if is that binding in that if an inspector comes in and checks office A and office B on the other side of the province has very similar scenarios, is it like case law or is it just case by case individual? That's the question that popped in my head as you were saying that.
Right. That's a great question. So simple answer is no. I mean, this isn't like a court process. This isn't like the Court of Appeal announcing a new change in the law. All these inspectors, and this is one of the frustrating parts, of course, is you can have conflicting decisions. So they will try to give each other some deference. And if one inspector has looked at a situation and another inspector looks at one that's very similar, they may well look at that decision and be influenced by it. But it's not a binding decision in that sense.
Important information for us going forward. So those of you who, do you have anything else to add to this discussion? Because I don't have any more questions. You've answered a lot of what I think my viewers want to know, because that's the predicament all of us are in.
No, the only thing I will add is that a lot of the issues that we see, and this is not new in the pandemic, but most of the issues we see are because of a lack of information and misguided notions about what your rights are and what they're not. So people refusing to work have this misguided idea that they can just decline to go back to work. And I have so many employers I've spoken to who don't think they can do anything about it. So make sure you understand that you do have some rights. And this, on the flip side, so many employers assume they could lay people off temporarily. And in many cases, they didn't have the legal right and they expose themselves to risk. So, I guess what I'm saying here is make sure you understand and don't make any assumptions.
I think that's some great advice, and it's free legal advice. So
don't find that often.
No, you don't. Date when you can get it. So my closing comments is if you are in a situation and you do want advice, reach out to an employment lawyer, either Stuart or there's a whole bunch of them in Ontario. Please make a decision and get the right information, because if you make a decision after the fact, it's often a lot harder to fix it. Correct?
and a lot more expensive.
Anyways, thank you very much for joining us. Stay tuned for our next episode. We're talking about some other things, including the CWS. Thank you. Bye-bye.
Thank you.